Para 32. Dr. Abhishek Manu Singhvi, the learned senior counsel appearing for the petitioner, made detailed submissions broadly on the following aspects. Item A. The governor, in exercise of his functions under Article 200, is required to act on the aid and advice tendered by the Council of Ministers. Sub-item 1. The governor is merely a titular or de jure head of the state, and the task of governing the state is entrusted to the chief minister and his council of ministers, who can be said to be the head of the state de facto. The powers vested in the governor under the constitution must be exercised on the aid and advice of the council of ministers headed by the chief minister. Item 2. The Constituent Assembly debates indicate that the framers of our Constitution envisaged the position of the governor as that of a guide, philosopher, and a friend of the government and the people in general. Item 3. The Constituent Assembly, in its wisdom and in consonance with the position of the governor in the parliamentary form of government, removed the phrase "in his discretion" from the substantive part and the first proviso to Section 75 of the Government of India Act, upon which Article 200 was modelled. Item 4. The constitutional scheme does not envisage that the governor would have the power to veto bills duly passed by the state legislature and would be capable of supplanting the policies of the government with his own discretion. The governor cannot sit over the bills enacted by the legislature indefinitely, as that would be against the interest of the people who elect the government, with the aspiration that the government would legislate in their interest. Gubernatorial procrastination is a new phenomenon and requires judicial intervention for finding a new solution for it within the constitutional framework. Item 5. Placing reliance on the Constitution Bench decision in Shamsher Singh quoted Supra, he submitted that although the executive power of the state is vested in the governor, yet it is actually carried on by the ministers under the rules of business made under Article 166, subsection 3. Further, the President or the Governor act on the aid and advice of the Council of Ministers, with the Prime Minister as the head in the case of the Union and the Chief Minister as the head in the case of states, in all matters which vest in the executive, irrespective of whether those functions are executive or legislative in character. Item 6. Referring to the observations made by a constitution bench of this court in Ribia quoted Supra, it was submitted that the governor cannot be entrusted with such powers and functions as would assign to him a dominating position over the state executive and the state legislature. The governor cannot be accepted as an all-pervading superconstitutional authority. It was submitted that an examination of the executive and legislative functions of the governor in the context of the constitutional scheme clearly brings out that the governor has not been assigned any substantive role either in the executive or the legislative functioning of the state. Item 7. It was argued that this court in Nabam Rabia's quoted Supra has gone further to say that any exercise of discretionary powers of the governor is limited to situations where a constitutional provision expressly provides that the governor should act in his own discretion. Additionally, a governor may exercise his functions in his own discretion in situations where the constitutional provision concerned cannot be construed otherwise, and in situations where the clear intent underlying a constitutional provision so requires, that is, where the exercise of such power on the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. Item 8. In response to our specific question as regards the observations made by this court in BK Pavitra versus Union of India, reported in 2019, 6 SCC 129 that the eventuality in Article 254, Section 2 does not exhaust the ambit of the power entrusted to the Governor under Article 200 to reserve a bill for the consideration of the President. He submitted that the Governor may legitimately refer a bill for consideration at the end of the President upon entertaining a legitimate doubt about the validity of law. However, such reference of a bill can only be done with the aid and advice of the Council of Ministers and not upon the individual discretion of the Governor. Item 9. He further submitted that the said observations in B.K. Pavitra, quoted supra, should be interpreted to mean that even though the power under Article 200 is entrusted to the Governor, yet such exercise of power can only be done with the aid and advice of the Council of Ministers of the state. The Governor has no independent discretion under the substantive part of Article 200 for referring the bill for the consideration of the President. As is crystal clear from the Constituent Assembly debates, there is no independent discretion vested in the Governor in exercise of his functions under Article 200 of the Constitution. Although the power of reserving bills for the consideration of the President is a necessary channel for references under Article 254, Section 2, to save the competence of the state legislatures from being unduly restricted by the operation of the rule of repugnancy embodied in Clause 1 of the Article 254, yet such power is also subject to the aid and advice of the Council of Ministers. Item B. The Governor cannot reserve a bill for the consideration of the President when it is repassed by the state legislature with or without amendments under the first proviso to Article 200. Item 1. Mr. Singhvi submitted that the relevant consideration at the end of the Governor when a bill is presented before him for assent broadly should be as follows. Sub-item number 1. The first step is to ascertain whether the bill is a money bill. In cases of money bills, the Governor has to grant assent. Item number 2. Thereafter, the Governor must ascertain whether the second proviso to Article 200 is attracted, that is, whether the bill, if it became law, would derogate from the powers of the High Court. If the answer is yes, then the Governor must reserve the bill for the consideration of the President. Item 3. In all other cases, the Governor has three options to choose from when the bill is presented before him for the first time: to either assent or withhold assent or reserve the bill for the consideration of the President. Item 2. He submitted that after the Governor has withheld assent to a bill and returned the same to the Legislative Assembly, it is not open to the Governor to reserve the said bill for the consideration of the President once the Legislative Assembly repasses it with or without amendment. If the Governor wants to reserve any bill for the consideration of the President, he must do so in the first instance when the bill is presented to him for assent. The Governor can choose any one of the three options at the first instance, but if he exercises the option to withhold assent, then the option of reserving the bill for the consideration of the President ceases to exist, because the next step in such a case is to follow the procedure prescribed under first proviso to Article 200. Item 3. Explaining the reason for the aforesaid, he submitted that upon exercising the second option, the third option no longer remains for the Governor, as the first proviso to Article 200 comes into operation. Article 200 does not provide any scope to the Governor for the reservation of the bill once the second option has already been exercised. The decision of the Governor to go down the path of sending the bill back to the legislature precludes him from reversing his constitutional election subsequently by referring it to the President after the bill is returned to him subsequent to repassing by the legislature. Item C. The first proviso to Article 200 is attached to the option of withholding of assent provided in the substantive part of the article. Sub-item 1. The concluding part of the first proviso stipulates that if the bill is passed again by the legislature, either with or without amendments, the Governor shall not withhold assent therefrom upon presentation. The expression "shall not withhold assent therefrom" is a clear indicator that the exercise of the power under the first proviso is relatable to the withholding of the assent by the Governor to the bill in the first instance. This phrase constitutes a clear and unequivocal unequivocal constitutional prohibition against the governor. The role which is ascribed by the first proviso to the governor is recommendatory in nature and it does not bind the state legislature. Item 2. The first proviso to Article 200 expands upon the second option to ensure that the object of the article is not rendered odious as without the first proviso. Article 200 would allow the governor to indiscriminately veto bills by repetitively and subsequently withholding the assent and cripple an elected government for political reasons. Item 3. On the use of the expression may in the first provision to article, the first proviso to Article 200, placing reliance on the decision of this court in state of Uttar Pradesh versus Jogendra Singh reported in AIR 1963 SC 1618, the council submitted that in the said decision, while adjudicating the duty of the governor to refer the cases relating to government servants to the administrative tribunal under rules 4 subsection 2 of the civil service rules, which also use the expression may, this court had held that the word may is capable of meaning must or shall in the light of the context. He further submitted that where discretion is conferred upon a public authority coupled with an obligation, the word may, which denotes discretion, should be construed to mean a command. Sometimes the legislature uses the word may out of deference to the high status of the authority on whom the power and the obligation are intended to be conferred and imposed. The first part of the first proviso, item 4, the first part of the first proviso is mandatory in nature. It authorizes the governor to, as soon as possible, after presentation for bill for assent, return the bill together with a message requesting the House to reconsider the bill with the desirability of introducing any such amendments as he may recommend in his message. He submitted that this interpretation was also followed by this court in the decision in state of Punjab, quoted supra, by stating that governor must mandatorily follow the course of action indicated in the first proviso of communicating to the state legislature as soon as possible a message warranting reconsideration of the bill. Item 5. The governor can only return the bill when he has withheld the consent. The governor cannot be expected to keep the bill in his custody after withholding the assent, as it would amount to a pocket veto or veto which is contrary to the intention of the makers of the Constitution. Any acceptance of such suspended animation doctrine of a bill supposedly kept indefinitely pending by a governor would be grossly violative of the constitutional text, spirit and intent. Item 6. The Council, while highlighting the facts of the case at hand, submitted that the governor had returned the bills with the remarks, I withhold assent, which amounts to a clear withholding as per the second option of the substantive part of Article 200. When these bills were returned to the Legislative Assembly, the bills only contained a signed endorsement by the governor with the remarks, I withhold assent, and there was no message for reconsideration. In such a situation of simpliciter withholding of assent, the state legislative assembly cannot be precluded from reconsidering the bill and repassing the bill as the exercise of the option of withholding of assent brings into operation the first proviso, whereby such bills have to be returned to the state legislative assembly. Item 7. Once the first proviso comes into operation, the state legislature is bound to mandatorily reconsider the bills and pass them with or without any amendments as indicated by the expression House or Houses shall reconsider the bill accordingly in the second part of the first proviso to Article 200. Item D. A time limit must be read into the expression as soon as possible appearing in the first proviso to Article 200 to curtail the prevalent practice of gubernatorial procrastination. Subitem 1. He submitted that the expression as soon as possible provided in the first proviso to Article 200 does not provide any strict time limit to be followed by the governor to decide upon the bills presented for assent, but that should not and cannot mean that the governor can keep a bill duly passed by the state legislative assembly pending for indeterminate periods. This course of action is inconsistent with the phrase as soon as possible. counsel placed reliance on the following decisions of this court in support of his submission. The state of Telangana versus Secretary to Her Excellency the Honorable Governor for the state of Telangana and another, reported in 2024 1 SCC 405, has emphasized that the phrase as soon as possible has significant constitutional content and must be borne in mind by constitutional functionaries. Ramchand and others versus Union of India and others, reported in 1994 1 SCC 44, held that where for exercise of power no time limit is fixed, it has to be exercised within a time which can be held to be reasonable. Kesham Meghachandra Singh versus Speaker, Manipur Legislative Assembly and others, reported in 2021 16 SCC 503, had postulated a 3 months outer limit for deciding disqualification petitions filed before the Speaker. Messrs. Northeastern Chemicals Industries Private Limited and another versus Messrs. Ashok Mills, CA number 2669 of 2023, has held that where there is no time period prescribed by the statute, the court must undertake a holistic assessment of the facts and circumstances, conduct of the parties, and the nature of the proceedings to examine the possibility of delay causing prejudice to a party. AG Perarivalan versus State through Superintendent of Police, CBI or SIT or MMDA, Chennai, Tamil Nadu and another, reported in 2023 8 SCC 257, wherein while dealing with the delay caused by the Governor in deciding remission matters, this court exercised its powers under Article 142 of the Constitution, directing that the prisoner was deemed to have served the sentence. Item 3. Mr. Singhvi referred to Chapter 5 of the report of the Sarkaria Commission on Center-State Administrative Relations, wherein it was suggested that the Governor should make a declaration under Article 200 within 1 month from the date on which the bill is presented. He also referred to the Punchi Committee report on State-Center Relations, which recommended maximum period of 6 months after bill is presented to be the time limit to be followed by the Governor under Article 200. Section E. The observations made by this court in its decision in Valluri Basavaya Chowdhury are not applicable to the present case. Item 1. Mr. Singhvi submitted that this court in Valluri Basavaya Chowdhury, quoted supra, had no occasion to adjudicate upon the interpretation of the constitutional powers of the Governor under Article 200 of the Constitution. Therefore, the observations of the court in para 19 cannot be construed to be its ratio decidendi. At most, these observations could be considered as obiter dicta. Indeed, they may not even constitute obiter, but are mere observations totally unconnected to and unnecessary for that case. Item 2. He relied upon the decision of this court in Secunderabad Club versus Commissioner of Income Tax, reported in 2023 SCC Online SC 1004, to submit that in terms of Article 141 of the Constitution, only the ratio decidendi of a judgment, that is the reason assigned in support of the conclusion, is binding. He submitted that this court has held that what is binding, therefore, is the principle underlying a decision which must be discerned in the context of the questions involved in that case from which the decision takes its color. In a subsequent case, a decision cannot be relied upon in support of a proposition that it did not decide. Therefore, the context of the question while considering which a judgment has been rendered assumes significance. Item 3. He submitted that the obiter dictum of the Supreme Court is binding under Article 141 to the extent of the observations on points raised and decided by the court in a case. Although the obiter dictum of the Supreme Court is binding on all courts, yet it only has persuasive authority as far as the Supreme Court itself is concerned. Item 4. He further submitted that a decision is not an authority for what can be read into it by implication or by assigning an assumed intention of the judges and inferring from it a proposition of law which the judges have not specifically or expressly laid down in the pronouncement. Item 5. Lastly, he submitted that even if the decision in Valluri Basavaya Chowdhury, quoted Supra, is interpreted as a binding precedent, still such interpretation of the Article 200 would fall foul of the intention envisaged by the Constituent Assembly. Section F. Role of the President under Article 201. Item 1. On the aspect of the position of the President under Article 201, he submitted that the President is not required to mandatorily assent to the bill that is presented to him for his consideration after being repassed by the state legislature once such bill has been sent back by the President under the proviso to Article 201 in the first instance. Item 2. It was submitted that Article 201 does not contain the expression shall not withhold assent therefrom in the proviso, unlike the first proviso to Article 200. He further submitted that this court in Kaisar-e-Hind, quoted Supra, held that the assent of the President envisaged under Articles 31A, 31C, 254, Clause B, and 304, Clause B of the Constitution, respectively, constitutes a distinct class and category of its own and is different from the assent envisaged under Articles 111 of the President or Article 200 of the Governor. A bare perusal of Article 201 indicates that even when the houses of the state legislature repass the bill and present it for consideration in terms of the proviso to Article 201, there is no compulsion on the President to accord assent. Item 3. Just as the Governor, the President is also bound by the aid and advice of his Council of Ministers under Article 201 of the Constitution. Such absence of compulsion of the President to grant assent to the bill reconsidered and repassed by the State Legislative Assembly is also subject to the aid and advice of the Council of Ministers. Whether the President should grant assent or not would be subject to the aid and advice by the Council of Ministers. There is no individual discretion vested in the President in granting or not granting the assent under Article 201. Section G. Malice in law and malice in fact. Item 1. He submitted that the Governor could be said to have committed violence to the constitutional framework by not adhering to the mandate under Article 200 of the Constitution and has also attempted to render the present writ petition infructuous during its pendency. Item 2. It was submitted that when the petitioner had approached this court initially, the Governor had kept 12 bills pending. Thereafter, the captioned writ petitions were heard by this court on 10th of November 2023, wherein it was observed that the present writ petition raised a matter of serious concern and issued notice to the Union of India, represented by the Secretary to the Government in the Ministry of Home Affairs. In light of the aforesaid, the Governor hastily, on 13th of November 2023, referred 2 bills for consideration of the President and withheld assent simpliciter to the remaining 10 bills. On 18th of November 2023, a special session of Tamil Nadu Legislative Assembly was held and the 10 bills were reconsidered and passed in the Assembly. These bills were sent to the Governor for consideration on the same day itself. However, the Governor, with a view to render the present petition infructuous, reserved the 10 bills for the consideration of the President. Item 3. In the last, the learned counsel submitted that the action of the Governor has been contrary to what was laid down by this court in S.R. Bommai Supra, wherein it was stated that the Governor is a very high constitutional functionary and he is supposed to act fairly and honestly in a manner consistent with his oath. It is for this reason that Article 356 places such implicit faith on his report. If, however, in a given case his report is vitiated by legal malafides, it is bound to vitiate the President's action as well. Para 33. Mr. P. Wilson, the learned senior counsel, made extensive submissions on behalf of the petitioner. For the sake of brevity, we are recording only those submissions which are in addition to the points already canvassed by Mr. Dwivedi and Mr. Singhvi respectively. Number 1. The Constituent Assembly, after long and detailed debates, decided to have a nominated governor in place of an elected governor and consciously deleted all expressions from the draft constitution which conferred individual discretion on the governor. He referred to certain portions of the report of the Sarkaria Commission in support of his arguments. Item 2. Article 91 of the Draft Constitution 1948, which enumerated the assent to bills by the President, had postulated a time limit of 6 weeks for the President to provide his assent to the bills presented to him by the Houses of Parliament. Item 3. Relying on the speech of Mr. T.T. Krishnamachari in the Constituent Assembly, he submitted that Article 200, as finally enacted, does not vest any discretion in the Governor to withhold a bill passed by the legislature except on the express aid and advice of the Council of Ministers. Item 4. He submitted that the Sarkaria Commission, in its report in Chapter 5, had observed that the Governor may reserve a bill for the consideration of President when it clearly violates fundamental rights or transgresses other constitutional limitations. The power to reserve bills could be used only in rare circumstances. In all other circumstances, the Governor needs to abide by the aid and advice of the Council of Ministers. Therefore, Article 200 does not confer general discretion on the Governor, but mandates him to act in accordance with aid and advice of the Council of Ministers. Item 5. He submitted that the fear anticipated by Sri H.V. Kamath as regards the difficulties that may arise due to the use of the phrase as soon as possible during the discussion on draft Article 91 is exactly what has been happening in the states of Telangana, Punjab, Kerala as well as in the petitioner state. Thus, this court must intervene and put the matters on quietus by declaring that it is deemed that assent has been granted to the bills and declare the action of reserving bills for assent of the President as ultra vires. Item 6. He submitted that the 10 bills which are the subject matter of present writ petition were dealt with by the Governor during the pendency of the writ petition in the manner referred to in paragraph 13 and 14 respectively of the third amendment application interim application number 216164 of 2024. Therefore, all unconstitutional acts of the Governor remain for consideration by this court as they are actions pendente lite, and this court has the power to turn the clock back and restore status quo ante. Section 2. Submissions on behalf of the respondents. Para 34. Mr. R. Venkatramani, the learned Attorney General for India, appeared for the respondents and submitted as follows. Item A. The Governor, while acting under Article 200, is not acting in exercise of ordinary discretion, but is acting under a constitutional responsibility. Thus, even if it is assumed that the Governor has no individual discretion, he may still withhold assent to a bill as per his constitutional obligation. Item B. He submitted that having regard to the high level of responsibilities entrusted to the Governor in dealing with bills presented for his consideration, the Governor may reach out to the Council of Ministers for advice in order to know the legislative intent and be benefited as well. However, when on the plain understanding of the bills, the Governor finds constitutional contraventions or seriously debatable issues of the Constitution, he may apply his mind with or without the aid of the Council of Ministers. This principle of an area of constitutional deliberation prior to the Governor taking any call under Article 200 cannot be subjected to or put into any straitjacket formula. Item C. He submitted that when new issues and concerns of legislation involving federal structure of the polity of the nation arise, it is important that the role of the Governor is neither stretched beyond a point nor should be allowed to be diminished to a status of no consequence. Item D. He submitted that in the instant case, the Governor was persuaded by the observations made in Valluri Basavaya, quoted supra, which suggest that when assent is withheld, the bill will cease to exist. However, if the Governor chooses to follow the procedure under the first proviso, wherever it will be of relevance and of importance to follow, then the Governor would become bound by the mandatory stipulation enunciated in the first proviso. Item E. He submitted that the single minded focus of the governor was to ensure that a repugnant law, if allowed to be on the statute book, would open the scope for maladministration of universities and impede the avowed object and purpose of excellence in higher education, placing all power in the hands of the state government as opposed to the chancellor. It is only with a view to avoid such a situation that the governor withheld assent to the bills in question. Item F. On the aspect of reservation of the bills for the consideration of the President, he submitted that there is nothing in Article 200 that suggests that the Governor ceases to have the authority to refer the matter to the President after he has withheld assent to the bill in the first instance. If this authority is available at the time of withholding of assent, the same cannot be taken away or not made available by the state government acting on their own motion under the first proviso. Item G. In furtherance of the aforesaid submissions, he submitted that for all practical purposes, the bills forwarded by the petitioner state on 18th of November 2023 should not be treated as sent by the governor acting under the first proviso. Bills that are sent outside the procedure contemplated by the first proviso would be open for consideration by the governor for any further course of action, including reference to the president. The principle of power coupled with duty underlying Article 200 demands that recourse to reference to President even after initial withholding of assent by the Governor be read into the article in order to make the power effective to achieve its purpose. Item H. He submitted that on a proper reading of the substantive part and the first proviso to Article 200, it will be seen that four courses of action are available to the Governor. The observations made in the state of Punjab quoted supra decision may thus warrant a qualification or an additional statement to fine-tune the scope of Article 200. On the issue as regards whether the first proviso is attracted in all the instances of withholding of assent, he submitted that the role for the first proviso is confined to cases where the bill may not be hit by any constitutional limitation, is within the competence of the legislature, but may admit of changes, amendments, etc. Such amendments or changes that the governor may thus suggest within the scope of the first proviso will not be relatable to matters such as repugnancy. With the perception of repugnancy, the focus of the governor will be outside the first proviso. He argued that even though this court in state of Punjab, quoted supra, has opined that the exercise of power under the first proviso is relatable to the withholding of the assent by the governor, yet this view may require a further qualification that in the constant context of repugnancy, unlike any other reason for withholding of assent, the governor need not necessarily proceed to act under the first proviso. The first proviso perhaps cannot be read to be pressed into service when both the governor and the state government understand the repugnancy dimension. In the event the state government decides to clear the repugnancy or any other hurdle, it may itself seek the assent of the president. In such an event, the state government may also ask the governor to refer the matter to the president for consideration. Item J. He submitted that in the present case, as the president has withheld assent to the bills in question, therefore, in terms of the statement of law in Hext Pharmaceuticals quoted supra, the action of the president in withholding assent is not justiciable. What cannot be directly done by seeking such justiciability cannot be indirectly achieved by the claim that the action of the governor in forwarding the bills in question to the president was beyond his authority. Item K. He submitted that the exposition of Article 200 as done in state of Punjab quoted supra is sub silentio, as this court while making the said decision did not take into account the observations made by the Constitution bench in Valluri Basavaya quoted supra. Item L. In the last, he submitted that the matter may be referred to a larger bench of this court so as to harmonize the observations made in B.K. Pavitra, quoted supra, Valluri Basavaya, quoted supra, and State of Punjab, quoted supra. Para 35. Mr. Vikramjit Bannerjee, the learned Additional Solicitor General, appeared for the correspondence and submitted as follows. Item A. A reading of Clause 1 of Article 163 categorically provides that the governor ordinarily is aided and advised by the council of ministers headed by the chief minister. However, there is an express discretion vested with the governor for exercising functions under the constitution which permeates all of the provisions that require the governor to exercise his or her power, including articles 200 and 201. Item B. Placing reliance on the decision of this court in MP Special Police, quoted supra, he submitted that normal rule is that the governor acts on the aid and advice of the Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion, and the exceptions are not exhaustive or limited but differ as per the facts of each case. He further submitted that the aforesaid decision recognized that the concept of the governor acting in his discretion or exercising independent judgment is not alien to the Constitution. There may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which by its very nature is not amenable to ministerial advice. An instance of a situation curiously similar to the present case is discussed where bias was inherent and manifest in the advice of the Council of Ministers as the proposed bills sought to fundamentally encroach into the role of the governor as the chancellor by seeking to substitute chancellor, who is the appointing authority of vice chancellors and also the disciplinary authority, with government. The state government has impugned the notifications issued by the governor in the capacity of the chancellor for constitution of search committees for appointment of vice chancellors for state universities. Additionally, the bills were collectively aimed at seeking to control the coordination and standards of higher and technical education research, which fall under entry 66 of the union list under the 7th schedule of the constitution. Item C. Placing reliance on the decision of this court in Purushottaman Nambudri versus K State of Kerala, reported in 1961, SCC Online SC 361, he submitted that the idea of reading in a time limit in Articles 200 and 201 respectively had been deliberated upon and expressly rejected by this court in the said decision. Item C. Issues for consideration. Para 36. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the following question, I think this can be done in another video.